Hey everyone, welcome back to the YMyHealth podcast. It's your co-host Melissa Schenkman here. And on this episode, we're going to be talking about something that's really important to our community, which is women's health. And a lot of times we talk about women's health from the angle of going to get preventative care and other things. But today we're going to be talking about it in terms of protection in your job in pregnancy. And it's not something that people often think about until they get to that point in their lives. And there are a lot of things out there that people are not aware of. And this is going to be a great opportunity to learn things not only for yourself, but for friends and family as well. So we're so fortunate to have Paige Sparks with us from Sparks Legal. She's an employment attorney, founder of Sparks Legal, and also Noelle Murray of Sparks Legal here with us as well, who has really developed expertise in this area of pregnancy related law and some of the big changes that have happened in the past 12 months, which we're going to be talking about. So, welcome, Paige and Noelle.
Hi, thank you for having us.
Hi, Melissa. Thanks for having us back. We always love
You're
to be on
so
the podcast. Before we get started, though, I do want to say everything Noelle and I say is just our personal opinion. It's meant to be informational only, not to be construed as legal advice. We hope that people can take away information that will help them do their own research or find a lawyer. So, just very clear on that. But thank you for having us. We're so excited to be back.
Thank you so much. So excited to have you. Well, first, just to start, I'm very curious because Noelle, you have a particular interest in this area, uh, as well. In addition, obviously, Paige, your years of experience. But Noelle, I know you've recently, I'd say, past what 6 months or more, been really diving into this. And so I was wondering, kind of what you know initially got you interested in learning about what legal protections are out there for pregnant workers.
Well, thank you. I think my interest I started noticing how hard pregnancy was on women who were working when I watched my sister's pregnancies. All of them had hyperemesis,
Mm.
which is a condition in pregnancy where, you have morning sickness, and then you have hyperemesis, which is like times 100. And oftentimes they were so sick, they were bedridden, they couldn't even keep ice chips down. And, I always kind of asked them, well, what do you do in your job? They were very fortunate where they could stay home, but the advice I was given was you either take leave or you get fired, because if you can't do your job, like, there's nothing you can do. So, I always remember just being a woman, and that you're always told you have to either choose between being a mom or having a career. That never sat well with me. And I think working for Paige, and we see a lot of employers, treating their pregnant employees just completely unfairly, and it really bothered me, and that's kind of what sparked my interest.
Mm. Very, very interesting, and makes complete sense as well because you don't really hear about, well, what do you do in a situation like this? And people work so hard to get to where they're at in their jobs as
Yeah.
well, and so it's really challenging. And kind of as you learned more about what protections are in the law to protect pregnant workers, what has surprised you?
I think the biggest thing that has surprised me is these protections for pregnant women are very recent, only through 2024. And just in this day and age, you would think that we would have made bigger strides in protecting women and their jobs. And we haven't until last year. And that was the biggest shock for me.
Oh, I bet. I bet. And with Paige, through the years, you've had so many clients at this point. I know, Noelle, you're earlier on in your career, and have a very exciting career ahead. But with you, Paige, when you've had clients who have come and they've brought cases of workers' rights violations that occurred in relation to pregnancy, when you've talked through the existing laws at the time with them, what have been some of the things that people didn't have knowledge of and some things that you told them that were just a complete surprise?
So previously, it was really unfortunate if someone would come needing help or an accommodation for their pregnancy. If they did not have a high risk pregnancy, there really was limited options for what we were able to help them do. And so that's frustrating because there are many symptoms that a lot of women, if not most of them, when they're pregnant, experience, like having long-term nausea. Noelle said the fancy medical word for it, so I can't I can't say the word,
Oh,
but
yeah.
like those are all short-term symptoms that were not technically a disability under the ADA, so they didn't require accommodation. And before,
Mm.
disability or pregnancy on its own didn't get an accommodation unless it was high risk. So those were all really unfortunate hurdles that would stop us from being able to help a lot of people. And I'm so proud of Noelle. So when she first started, she was my little pit bull going after these pregnancy discrimination cases. And she took a real special interest to this right when the law was all changing too. And I was like, yeah, go get them, because now we have not only it's not even a level playing field, it's a better playing field for pregnant women and a lot more protections now. So I'm so glad that the law has changed.
Oh, absolutely. So am I. And so are so many people as they're listening to this, for certain. And over the past, let's say 3 decades even, right? Looking back, what types of laws and protections have been in place to protect women in their employment when they became pregnant, Paige?
Yeah, so the older law, like I mentioned, you had to have
Mhm.
some kind of high risk part to it. So, like, if you had
Okay.
gestational diabetes, that could elevate the pregnancy to a disability standard under the old law. And we were really following that, like, ADA disability standard for pregnancy and kind of making this, sometimes we get a little creative to try to help our clients and like a little creative, a lot creative. And we're trying to make this like square peg fitting around hole to get them
Mhm.
accommodated. But now we don't have to do that. Under the Pregnant Workers Fairness Act, any pregnancy, you can request an accommodation. You don't have to have that extenuating circumstance or a worse condition. So now you can request accommodation for just having a pregnancy, whether you need to sit down or need breaks or need time to take water. Or, like, right now, we have a client who requested a work from home accommodation because she's so nauseous in the morning she can't drive her commute to work. And so there are really a lot more protections now that we no longer have this outdated historic law of not accommodating it. And I will tell you, a lot of employers are not up to date with the changes. We are bringing a lot of these cases because the employers haven't kept up. They're still going under that old standard. And, ignorance of the law is not a defense. So we are representing a lot of people right now that are actually still employed and fighting to get them accommodations. And I love when we get a lawyer on the other side because it's kind of like this unspoken, we're like, hey, so we've updated their policies and now your person can be accommodated. I'm like, okay, great. And sometimes it ends there and sometimes it doesn't. But now there are so many more protections where before, I was kind of trying to have to sell a disability when sometimes it might not have been there.
Wow. No, that's just incredible, and I'm really glad that we're gonna be spreading more awareness about this, through the podcast for sure, and we're gonna talk more about the Pregnancy Workers Fairness Act as we go through the episode, but I have to ask you the question that so many people have, that every woman probably, or almost every woman in America always has, when they find out that pregnancy, when it comes to legal documentation and you're filing for things, it it's really written as a disability and considered as a disability, and so I'm wondering, just in your opinion, from your experience, why? And what have you been told through the years, like, why that particular term has been affiliated with pregnancy?
I do think it's because there was no equivalent protection before, because that's how we had to phrase it. So, like, being pregnant is not like necessarily a full body disability, and that's not how it would have been pled before. But that's how a lot of employers either perceived it or associated it with that kind of disabled standard or having a disability, is because there wasn't that protection before. And we were kind of using close enough language for similar laws. So, I do think that's why a lot of people are kind of stuck in that way of viewing it that way. But again, now, because you don't have before you had to have like disability plus pregnancy equals you can ask for an accommodation. Now we don't have that whole equation. You can just be pregnant and ask for the accommodation. So hopefully, as people continue to learn of these new changes, it'll kind of lose that connotation, because I think that can we start to creep into like the perceived disability with employers of that, because if they start just assuming you can't do stuff because you're pregnant, but you can and you haven't even asked for an accommodation, that can be unlawful too because of that old mindset.
Mhm. No, excellent point. Absolutely excellent point. And 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 it's so promising that there's something that is gonna separate the 2, because they're
Yeah.
such different things, and to see that on paper even. But for you, Noelle, as you've been, being a law clerk for Paige and for a firm, I know you've come across, of the many things you've come across, are the Pump for Nursing Mothers Act. And it was signed into law, I believe in 2022, something around then. So it's relatively recent and updated as well. How would you say this is a helpful protection in the workplace? And what does it lack in protection as well?
Yeah, absolutely. Well, the Pump Act was a great first step. It allowed pumping mothers to nurse and have a space to nurse and everything. It does have a lot of shortcomings that the Pregnant Workers Fairness Act actually helps out with a little bit. It kind of extends those protections with the Pump Act. So, for example, in the Pump Act, it's only for 1 year after childbirth, and some women choose to breastfeed past 1 year. So there's
Yeah.
an issue. Um, there's no statute on how long or how frequent the breaks an employer can like give you the breaks to pump or nurse.
Mm.
So that could be an issue. There are also unpaid breaks, and that's an issue for any hourly employee. That's unpaid wages that they're losing out on. So with the Pregnant Workers Fairness Act, it does add a little bit of more of extensions. For example, it's considered a reasonable accommodation when possible to your employer to provide their employees pumping to pump near a sink or have a refrigerator next to them. All those, and like an extended amount of breaks. There's not. It's just it gives a little bit more protections than the Pump Act originally gave.
No, that's wonderful to hear, and it's incredible what the shortcomings are when you
Yeah,
get down to the details
yeah,
of the Pump Act,
sure.
including with hourly workers, which is there are a lot of hourly workers out there. So, that's a really an important distinction to make. And when you think about it, the fact that there's been such a limited amount of legal protections for women in this country who are pregnant for such a long time, as you were putting out in the beginning, is really hard to wrap your mind around, I feel like. And yeah, and so, um, we make up, I don't know the exact numbers, but we make up at least half the population of the country.
Yeah,
So that's a lot of people to not, uh, potentially even within that group, millions of people who are affected by not having those legal protections in relation to their jobs. And as we were talking about, so last year, it's big, exciting uh, milestone here that happened, far as strides in getting greater protection for women is the Pregnant Workers Fairness Act. So how does that protect pregnant women, and um, does it provide, what it provides, does it differ at all whether you're high risk or medium risk pregnancy? Uh, how does that work as well?
sure, sure. And one of the great things about the Pregnant Workers Fairness Act is that it covers past, current, and future pregnancies. So that's a huge step. So it protects women in a different way than it did before, because before, basically, if you were really, really sick, like for example with hyperemesis, well, your options were to take unpaid leave or get fired. But now this act has provided women with the opportunity to remain in the workplace when it is possible, as long as their employer can provide them with some kind of reasonable accommodation to keep them working. The goal is to keep them working and
Mm.
allow them to keep their job. So it doesn't matter if the pregnancy condition is severe, if it's moderate, if it's minimal, if it is ongoing or comes in episodes, that the Pregnant Workers Fairness Act covers all of that, does not have to be a severe or ongoing level. Um, and it really just it allows the employee to have some kind of protections when they need a reasonable accommodation at work, and their
Mhm.
employer cannot retaliate against them for asking that.
It sounds like, in comparison, when you look back at the history that we've been talking about, it sounds like the most wonderful law because of how many things it covers and how
Yeah.
honestly, as somebody will be listening to this episode, like, because it's not just, as you're saying, a current pregnancy, and
Yes.
then the timing of it, the risk level, all these different things, just there's so much thought there in
Yes.
comparison to what we've had in the past, and it's just incredible to your point that it's taken so long when it comes to qualifying. So you were already saying about, current pregnancy, past pregnancy, and I believe you said one other category. Um,
And future.
and future pregnancy.
Yeah,
Yeah.
family planning, all that stuff.
Okay. So far as, you know, if you could talk a little bit about what makes an employee actually qualify for protection under the Pregnant Workers Fairness Act.
Sure. There are actually two ways. So one way, the first way is very similar to the ADA, what makes an employer qualified for under the ADA, and
Okay.
that is that the employee can perform the essential functions of their job with or without a reasonable accommodation. But the other way is if the employee cannot perform their essential function in the jobs, they can still qualify under the Pregnant Workers Fairness Act if the essential function of their job can be performed in the near future, their inability to perform is only temporary, and their inability to perform their job can be accommodated by a reasonable accommodation. It can be fixed. So, like, for example, if a cashier needs to sit and they need a stool to help them do that while they're checking people out, that would be considered a reasonable accommodation. Because they are still able to perform their job as long as they have this reasonable accommodation.
No, that makes complete sense, and that's very, very helpful as people are thinking about this and how it would be best used and how you could actually qualify to have that protection. And
Yes.
there's a very long list of qualifying conditions,
Yes.
extend well beyond the current pregnancy. And Paige, in your experience too, I was gonna say, when you saw this list, were you very surprised by it? Because it seems pretty extensive.
Yeah, I'm always happy when they codify those kind of things because then we don't have to fight with the opposing counsel nearly as much when an issue comes up. Because I'd be like, look, they're on the list. But it's also not an exhaustive list. And some conditions can
True.
be considered a disability too, depending on what the actual condition is. So there is sometimes some overlap there. But yeah, anytime that it's spelled out like that is usually great for people on our side of the fence because it's a little less arguing we have to do when they can't be like, it's not technically under, and now it's nice because we could be like, yeah, it's right here. But yeah, it's important to note too, it's not exhaustive. So there are other things that can fall under there as well. But it is great that they gave us a lot to work with by revamping this law.
No, that's really, really helpful to hear, and because I was curious because when I saw it, it's quite extensive, and I didn't know how it kind of matched up to other things. And Noelle, when it comes to that list, what are some of the qualifying conditions? And I think people are going to be very surprised about some of the qualifying conditions
Yeah.
on the list in a good way. I say this in a good way. Yeah,
Yeah, and I think they'll be pleased because it is so broad.
yeah,
I think we are as we're learning more about pregnancy, we know how debilitating it can be and how many issues can arise during pregnancy for different women. So some of the conditions that are listed can be physical conditions like the nausea, if you need to go get like fertility treatments, infertility counseling, for if you need an abortion, this is all covered under the act. If you have a miscarriage and you need time off to go to the doctors or to rest, this would all qualify under it. Gestational diabetes, low milk supply, clogged milk ducts, and it's not only just physical conditions that women are affected by in pregnancy, it's also mental conditions.
true.
So for an example, for a past pregnancy that they might need to be accommodated for is hormonal changes, postpartum depression, current pregnancy, anxiety they're experiencing. All those things are all covered under this act. So it's a very broad range. Pretty much anything that you experience during pregnancy that is debilitating is covered under this act.
That's absolutely wonderful. And I know as far as on the fertility side of things too, I was going to say there are so many people in the millennial generation who are going through different types of treatments for fertility, and they are not easy. They are
Yeah.
very expensive, but they also take a huge toll on your energy levels.
Yeah.
And so just of one thing to name, and so that's wonderful that that was placed in this act. As
Yes.
something that's qualifying. That's gonna
Especially
help a
for the
lot.
miscarriages, like that we didn't really have much
Yes.
to help people with that for before if you needed to go get a DNC and your employer wouldn't accommodate you. Like it's really great how expansive it is.
Oh,
Yeah.
absolutely, absolutely, and when it comes to someone who says, "Okay, I have one of these conditions, and I've learned about this act that's in place," aside from FMLA, which we're going to talk about a little bit as well as how the two connect, but they hear about this. What are the steps that they need to take to get protection under this law? Paige.
Well, first and foremost, at some point to have the law apply, you have to disclose the pregnancy. And I always prefer when our clients do that in writing. That way we can prove when and how you did it, the exact date and time. And what I always suggest doing, like if it were me, I would disclose my pregnancy if I'm asking for accommodations in the same breath that I'm asking for those certain accommodations. That way, we can make sure it's not used to discriminate against someone. And if things start happening that are weird after that triggering event, then we can track them back to kind of allege retaliation if any employer gets weird about accommodating someone. So first and foremost, the employer has to know about the pregnancy in order to accommodate it. It breaks our heart when people will contact us and they've never disclosed it to their employer, but they think they were fired in retaliation to issues they were having, like with attendance or whatever, but they were afraid to disclose it, and so they never did. Well, I can't prove you were discriminated against because of your pregnancy if the employer can say they didn't know. So I cannot stress that enough. That's like first and foremost the most important thing to do. I know it's scary because we're kind of taught don't say anything or they'll make plans to fire you because they don't want to have you out on maternity leave. Like we're all very afraid of that because of what we've heard of happen to others in the past. But with these new laws moving forward, the employer has to be put on notice in order to be required to give that accommodation. So first and foremost, that's the biggest issue and kind of where we see a lot of people don't take that step. And I know it's scary, but really it's not as scary under the new law, and we need you to do that.
So that's incredibly helpful advice for people. And always, I know you're so big on this, and why you were so helpful at your firm with getting people the protection and they deserve for their rights is documentation.
Yes.
Always about documentation and keeping that track record. So very
And I know a
important.
lot
And
of people panic, Melissa, because they're like, "Well, I don't know what to
oh,
say," or
sure.
like there's no
Oh yeah.
magic language you have to use. Like you can we'll write it for you if you send an email and nicely ask for help. Like we do that for people all the time. But like
That's
it
awesome.
literally be as simple as, "Hi, dear manager. I'm writing to let you know I'm pregnant with an expected due date of this. Because of my pregnancy, I'm requesting the following accommodations. Here's a note from my doctor. Let me know if you need to discuss this further or let me know if I can be accommodated." It can really just be that simple. And after disclosing it again, if things start getting weird, that's when we need to look at, okay, if they're being weird, is this discrimination? Because then you need to use that language trigger protections for the discrimination. But I think that's where a
Yeah.
lot of people get hung up on if they're afraid to disclose it. You don't have to send it on like legal letterhead. And in fact, that's kind of way overpowering. You don't need to do that. Just ask, disclose the pregnancy and ask for what you need, and then the ball's in their court. And I think most of the time we see employers do the right thing, but every once in a while when they don't, you want to make sure you put all that in writing because now we can circle back to that.
Oh
And I just wanted to add,
yeah.
the fears that women had about disclosing their pregnancies were completely valid up until
Right.
about a year ago. Because before an employer technically could say we could fire you or put you on unpaid leave, and that's very scary as a woman. Again, we're being caught in between this choice of do you want to be a mother or do you want to have a career? Because apparently you can't have both. And the but the whole point, the beautiful thing about this Pregnant Workers Fairness Act thing is that it has put a stop to that now.
Mm.
So it's so important to encourage these women to tell their employer and to stand up for themselves and to ask for these accommodations when they need them, because now this federal statute is going to protect them should their employer retaliate against them by putting them on unpaid leave or firing them.
No, well, that's a huge, I think, such a huge relief, and I agree with what both of you are saying because I know of people from past work myself who have come to me and told me that they were pregnant and that they were afraid to say something and they waited months to say something because they were afraid they wouldn't get certain promotion or they wouldn't,
Right.
protect their right. So I can totally, I've seen firsthand, um, not on the legal side, but from the just fellow employee coworker side of people having that that same reaction. So having this type of protection and even knowing that if you were to ask, an employment attorney, and specifically Paige, if people were fortunate enough to work with you and with Noelle and your firm, to be able to even ask for that wording, like, oh my gosh, what a relief, because it is hard to know what to say too.
Yeah, we're
So
happy to help. If anyone ever emails and just kind of generally tells us what's going on to the extent we can, we do that for free too. We just want to help people. And then if something happens, we can also provide more resources, like if we're not in the right state. But like I said, most
sure.
of the time the employer does do the right thing. We're just kind of holding your hand to let them know you're pregnant. You know what I mean?
Yeah, exactly. But in this case, for most people I know, you do need that hand holding, because it is
Sure.
it's scary with your job. So no, absolutely.
Right. Like
And
if we didn't do this, I'd be scared to do it too. But I kind of we know the limits and what we can and can't do and should do. And so we can
sure.
kind of confidently help with that a little bit more. And we're happy to.
Well, thank you. No, that's wonderful, wonderful to hear. And Noelle, how would you say the Pregnancy Workers Fairness Act differs from the American Disabilities Act, right? Because the disability part of that was previously how pregnancy was tied to that and getting protection.
Sure, sure. Yeah. Well, the ADA covers disabilities, and pregnancy is not a disability under the ADA unless it creates some kind of disability level condition. I think Paige had mentioned gestational diabetes
Right.
before. So, the Pregnant Workers Fairness Act is going to cover everyone who has a pregnancy or childbirth related condition that might not be considered a disability under the ADA. So, it's back to the theme of this does not have to be severe and ongoing. This can be a moderate and come in episodes. It doesn't have to be a disability for you to be protected, and nor should it.
Right. Oh, absolutely.
And as a
Absolutely.
practical example, Melissa, like with older
Yeah.
cases, Noelle and I would get someone before we knew what this new law was going to look like. We'd be like, "Dang it, they don't have diabetes," and it's like you never want to be saying that. So like it's just great that we don't even have to go there now because of like Noelle mentioned, you don't need that qualifying condition anymore.
Right.
No. Awesome. Oh, absolutely awesome. And far as documentation, which, as I was mentioning before, one of your favorite things,
You
but
know I
also a
love
very, very
FMLA. I said, I love FMLA and
I
documentation.
know
Those are
you do. I know you do. I know you do. So what type of documentation, even with this act, are employees required to provide?
So for the kind of documentation, employers don't have to have like a set form or anything like that. And I
Mhm.
always recommend to our clients that if they can get doctor's notes, that certainly helps. It helps
Okay.
prove that you need what you're requesting. It's not always required, but that's usually the first thing an employer is going to ask for, especially if you're asking for an accommodation, is for your doctor's note. So if when you find out you're pregnant, ask your doctor for a note. You have it to use when needed. The other thing is if you are going to start having like absences or issues or things,
Mhm.
always make sure you are, instead of just calling in sick, send an email, send a text, make sure it's in writing. That counts as making your paper trail and documentation too. That way, in the future, if something did happen, you know exactly what dates were out and we can make a timeline if there is any kind of retaliation or anything like that. And then also, because you know how much I love FMLA, I always
I
tell
do.
all of our pregnant clients, like, get intermittent FMLA as soon as you can. It's there to use as you need it. It's unpaid leave unless your employer offers something different. And you can just
Mhm.
take a day as you need it. Like, I have one client right now, just as a practical example, where she's
Yeah.
taking intermittent FMLA for days she needs related to a non disability pregnancy, just a regular pregnancy. And I was talking with the opposing lawyer today who's like, well, she's on this performance improvement plan because her attendance is down or whatever. All the dates were her FMLA dates. So you can see how
Oh
that's a
my god.
problem for them and why you should
Yeah.
document it though. Like you should always know what your dates are that you're using for those kind of things in case you need them later. But that's almost as important as disclosing the pregnancy in the first place.
Oh, I can totally see
Um,
that.
I would I would like to add something as
Yeah.
well for on the employer side. I know there's some confusion about what employers exactly are allowed to request from their employees in terms of
Yeah.
documentation related to the pregnancies.
Oh,
So
good
under
point.
the EEOC Under the EEOC's guidance, there's a reasonableness standard. So, employers are allowed to ask for the minimum necessary documentation to either support the claims that they're pregnant and have the condition.
Right.
They cannot ask for excessive documentation. So, an example of this is if you have an accommodation at work that you need to come in an hour later than usual because you have really bad morning sickness, right?
Mhm.
Your employer has the doctor's note saying that you need that accommodation. They know you're pregnant. Your employer can't require you to provide a new doctor's note every single time you
Mm.
need to come in late because at that point they're just doing it to be a jerk. Um, to put it lightly. Um, and stuff like that. So there's a reasonableness standard. Your employer can request very minimal documentation, just supporting that you have the condition, you need the accommodation, but they can't be, if you're an employee and you're asking for a new uniform because
Yeah.
you have a growing belly, it would be unreasonable for your employer to ask for documentation or a doctor's note to support that. It's going to depend on like a case by case basis.
Yeah, but that's a really interesting point because people can feel like they're in such a tough spot, right? Because they want to, right, protect their job, and so they're trying to take and give that, you know, excessive, even though they realize it's excessive. So it's nice, very nice to know that that actually isn't what they need to be doing, and that
Yeah.
they're protected by law with providing what they need from the beginning, and then
Yes.
after that, yeah, that they should be able
Yeah.
to get all these different accommodations. And um you're also I was gonna ask you, far as I know there's some different things where they're just, and I think you were talking about this a little bit too, um, when employers can't ask for, like, is there certain times in which they can't ask for certain supporting documents, throughout this kind of whole timeline of things?
Sure. I think, and I'm gonna let Paige piggyback off this really quick,
Or
because we have a good example of this.
Yeah,
Oh,
so
They
good.
again,
Noelle read my mind. Yeah.
yeah,
So the
um,
oh, sorry, no, I didn't mean to get I'm excited. Go ahead.
no, I was just gonna say again, like they can ask for minimal documentation to support what the employee needs. So a doctor's note saying she needs to have more frequent breaks, or she needs to sit down, or she needs to come
Mhm.
in later. That's the they. But I'm gonna let Paige finish off with this a really good example of what they cannot ask for.
Yeah,
Yes,
Noelle and
please.
I are on the same brain wavelength here because I was like, "Oh, we have that good example." So we actually have a pregnancy discrimination client right now that did that when she first requested accommodations before we even got involved because she just did it on her own, like most people can and
Yeah.
should do. And the employer's response was to send this like way over broad release where they wanted all these medical records. She asked for an accommodation to have a stool, for example, and they were asking
Mhm.
for her psychiatric records and her
Oh my
doctor to
god.
put a note that she's not a harm to herself or others. Like all these crazy things that
Wow.
had nothing to do with what she was even requesting. And so again, we file a charge. We're putting this through the process. The company finally got a lawyer. That's the first thing this lawyer said was like, can you send me a copy of the release they had? They asked your client to sign. And I was like, yeah, I'd be happy to because it's really overbroad. And actually, during a conversation, because the company's always trying to downplay it to get the
Of course.
problem to go away. And they're like, well, we've revamped the policy. It's no longer that overbroad. Really, no harm, no foul under regular discrimination laws. And I'm like, aha, but because I know all this really well because Noelle keeps me very up to date on the Pregnant Workers Fairness Act. I was like, yeah, that might be true, but it is overbroad under the act just on its own. And of course, he was like, okay, and on to the next
Mhm.
thing we have to talk about. Because I'm like, yeah, it's different buckets it goes in now. The act is like a safety net whenever employers start doing weird stuff like that. But back to Noelle's point, it has to be reasonable. That's the operative language here. So if you request an accommodation for a chair, they shouldn't be telling you you need to get a statement from your doctor that you're not going to harm people at work. That's kind of bizarre. And so those are things to look out for.
So bizarre.
Yeah,
Wow.
and like the requesting this broad like psychiatric records, it's a very strategic bullying move on employers' part. It's just another strategy to try and run out pregnant employees out of the office, or their jobs. And honestly, it's not okay. And we love going up against employers who try to do that.
Yeah. No, absolutely. I can see how that's would be very rewarding to protect people who rightfully need to be protected.
Yeah.
So that's quite an example. Thank you for sharing that with us. Uh, far as the types of accommodations that the law is specifically requiring employers to provide pregnant employees, what do those look like? Are there certain ones that have been kind of detailed out? I know you're mentioning the stool, but like, are there specific things that are on the list that like they're already required and they can't say no?
Yeah, so, there is a list of from the EEOC's guidance that they basically say it's going to be very, very hard for your employer to
Mhm.
explain why they can't provide this. And so their language is this is going to be this list is gonna be considered a reasonable accommodation in virtually all cases. And those are things that are like allowing an employee to keep or carry water with them, allowing them more restroom breaks, allowing them more breaks to get up and eat something, or if the employee is usually standing, allowing them to sit, or if they're usually sitting, allowing them to stand. Those four things are going to be, in virtually all cases, considered a reasonable accommodation. There is a list of other reasonable accommodations the EEOC has outlined, and I can certainly get into those. But those four that I just mentioned are going to be considered reasonable in virtually all cases.
Which just by an outsider's view looking in, like, that's, like, extremely reasonable,
Yes,
the types of
yes.
things, so it's really good to hear that that's on the list, and I just can't imagine, but I'm sure in the past, people arguing, saying that those weren't reasonable. I'm gonna
Well,
get that was a
yes.
first.
I
Yeah.
was just telling Paige, I was like, "Can you imagine being such an awful, miserable person that you
Mm.
would actually look at your employee and say, 'Sorry, you aren't allowed to carry water with you,' or
Yeah,
'You aren't
right.
allowed a stool?'" I mean,
Yeah,
And
yeah,
they've done it. There's employers that have done that, is the
I'm
sad
sure.
part.
yeah.
I'm sure. No, I have no doubt. Well, thank goodness for this new act to prevent that from happening again. And another thing that's interesting about this act is about the medical documentation. Um, it really affects how much of that seems to be needed. And so I was wondering kind of in your view, how has that been affected? And then also, why is this important, would you say, in relation to employees who have barriers to accessing their medical care to begin with?
Yeah. So the guidance actually specifically tells employers that they need to be mindful that not everybody has the privilege and the access to medical doctors 24/7. Um, and so that's again going back on there's a reasonableness standard when you're requiring medical documentation from your employees. And employers need to keep that in mind that not everybody has the time or the money and the privilege to go see a doctor every single time there's something wrong. So when the condition is obvious, then the employer just they really should try and work with them to give them that.
Oh, absolutely. If an employer pushes back, what are they required to do to not have to make that accommodation?
So the way an employer can try to not provide an accommodation is if they can show that it causes some kind of undue burden or hardship on the company, and that's what they use to say it is not reasonable, that it's an unreasonable
Yeah.
accommodation. And like kind of a crazy example, just to give an example of like piggybacking off
Yeah.
what Noelle said earlier, asking
Yeah.
for a stool or a place to sit is almost always going to be reasonable. Now, if I want to sit, if I'm pregnant and I want to sit and I want my manager to give me a foot rub because, it hurts to stand all day like that, they're going to say that's not reasonable. It's going to take more time. And it's just kind of like a bizarre request. And so there are other things,
Yeah.
though. And again, it's going to kind of mirror the ADA, where if an employer denies
Mhm.
an accommodation request, like let's say someone requests to work from home and that employer denies it because for whatever reason, their job requires you to be in the office and there's no work from home alternative. What they are still required to do is still kind of engage in that similar interactive process to see if any other accommodations may be available, like flex time or something. And I
Yeah.
also want to add a tip for your listeners too is pay
Please.
attention if they deny an accommodation request, if they're accommodating other non pregnant people with the same accommodation. We have a pretty contentious
Mm.
case right now where that's happening. Our client has requested to work from home for a couple of reasons, but also mainly because of her pregnancy, and the employer just outright denied it. They worked from home during the pandemic. They worked from home when the office flooded for a month during repairs with no issue and actually had like record
Mm.
sales. And they're letting other similarly situated male employees work from home, but they told her no. So those are all things to look out for. Like on its own, maybe it wouldn't trigger, but when you zoom out and look at the bigger picture, if it gets denied, immediately try to talk with a lawyer because those are the things that we dive into and start looking into to make sure that A, it was properly denied if there was a reason to, and if not, then getting you accommodated because pregnancy is not a lifetime condition. You know, when you need a pregnancy accommodation, you need it now. Most of the time yesterday. So like those are important things to look out for. But like Noelle had mentioned, most of the pregnancy accommodations we see are very reasonable. And most of the time employers accommodate them because if saying no to water is crazy. But yeah, when it doesn't happen is like you need to take next steps right away and not wait and see what happens next.
Yeah, excellent tip. Excellent tip. And FMLA, your favorite topic.
Our
I was gonna
favorite.
ask Noelle, but I have a feeling you're gonna jump in here. Um, Paige, so Noelle, how does when we think about FMLA, because I know a lot of people have heard of that. Some people have probably even gotten FMLA during their time as an employee for different reasons, and they're probably going, okay, well, how does FMLA fit into all of this? So usually people request that traditionally when needing to take extended periods of time,
Sure.
but now you have this Pregnant Workers Fairness Act. So how do the 2 fit together? Or do they
Yeah.
fit together?
Yeah, absolutely. So there are two different federal statutes, but they can go hand in hand at the same time. So the main difference is for the Pregnant Workers Fairness Act is to keep the employee working as long as they can be reasonably accommodated. So, the examples would be I just need to come in an hour later because it's really hard for me to. I'm puking 2 hours in the morning. It's hard for me to show up at 7 a.m. or something like that. But it's to keep them working. And FMLA is for when the employee needs to step aside and to have their job protected. So, an example could be like recovering from childbirth. You're gonna need some extended period of time where you need your job protected, but you have to step away, and that's the biggest difference. So you. And I think Paige has mentioned this before, is she encourages a lot of pregnant employees to take intermittent FMLA when they need to step away and use the Pregnant Workers Fairness Act when they just need to be accommodated so they can continue working.
Oh, that makes a lot of sense. I really appreciate you explaining that to us because I know that's something that people are gonna be
Yeah.
asking about as they're thinking about this. And Paige, if someone is in the process of trying to become pregnant or knows they are going to start fertility treatments or any of the other qualifying conditions under this act, when should they really initiate this process? And is there ever a point that it's too late to put the protection in place?
Do you mean for the FMLA specifically?
Oh, I'm sorry, for the Pregnant Workers Fairness Act.
Oh, okay, sorry, I just wanna make sure. See, I just wanna stay in FMLA and,
I
yeah,
know
so
you do. I know you do.
yeah, so with those kind of protections, usually you want to be proactive and not defensive. That's how you're going to make sure that your needs are getting met, and if they're not, you have a plan and you're not left scrambling without accommodation or in a tight spot where they start turning the pressure on you and you needed the accommodation and they're giving you the runaround. You got to find a lawyer and all that stuff. So what I always encourage people to do is plan ahead. Plan ahead if you're going to disclose it. Most lawyers like us do free consultations and you can at least know your rights for what you're asking for or what you're entitled to. Or like Noelle was just mentioning about the FMLA, you can take all these things at the same time. They're different laws that can work together. So like you can plan how you want to use your FMLA, whether you think if you had a really rough pregnancy and you need to use that while before you take maternity leave, then use it then. I have a lot of clients that will use it intermittently as needed before they take maternity leave, and then they use it for extra maternity leave because their employer only wants to give them X amount of weeks or whatever. And then you can also get, for those that are eligible, you can also get short-term disability benefits at the same time too, especially if your employer does not offer paid maternity leave for as long as you're going to be out. So there are a lot of options. I always tell people, especially with these things, do not wait until the last minute and kind of have an idea of what you'd like to do. That way, you know your rights and what's requested, and you're not. And again, being proactive instead of defensive is how you can protect yourself the most. I think.
Oh, great advice. Excellent point. Yes, proactive for sure. is the way to go. And as we wrap up this episode, um, Noel, what would you say are the top 3 things that you would like women employees across the country who are of childbearing age to know about the Pregnant Workers Fairness Act?
Yeah. Well, I the first thing is that times are changing. We are no longer in this theme where you have to choose between being a mom and having a career. And before, women might have been able to be pushed into unpaid leave or lose their jobs because they decided to be a mom. And now their employers must explore accommodations for them in order to keep them working. Another thing would be that this covers the entire reproductive process. That is, I think, one of the biggest things. This does not just cover current pregnancies. If you have some kind of condition from a past pregnancy or a future pregnancy, this is all covered under this federal statute. This also doesn't just include physical conditions, it includes mental health conditions as well. Those are important too. My last one would be that to remember that employers cannot retaliate against you for asking for help or asking for an accommodation. Okay, this is important because so many women are so afraid to speak up, like we were talking about earlier, and afraid to really disclose their pregnancy because they were afraid of being retaliated against. This is not allowed, and we are stepping away from that mindset, and we are entering into a new age.
Wonderful, wonderful things, takeaways for everybody to have, and also very empowering at the same time, very much so. And Paige, lastly, in your years of experience, fighting for employees' rights in so many different areas, um, within employment law, what do you feel, the fact that the Pregnant Workers Fairness Act has been enacted into law, what do you feel it means for protection of women's health and their employment and the future, really, of such protections in the workplace?
My hope is that this is going to strengthen where the gaps were before, from where the things we couldn't touch to before. Like if someone was ill from a miscarriage and they needed time off work, that's not long term. It wasn't a disability. And if it wasn't a disability of pregnancy, it didn't get accommodated. So now that has bridged that gap. So I'm hoping that we can use this to not only help people get accommodated and be protected during their pregnancy and not experience retaliation, but if it does, now we can go after them for when the employer does want to do things like this. And it's really going to help support a lot of working women all across the country because that is something important I'd like to note because it's something we see on social media misconstrued all the time. This applies to all states, all even the at will states. It doesn't
Mhm.
matter. It's a federal law. So this is something that, we're hoping we'll see kind of change those stigmas and work through the system and hopefully in the future, women aren't going to be afraid to disclose their pregnancy because they know that will actually protect them. And so that's what I'd like to see.
Oh, absolutely. Definitely, definitely. We all want to see that, and it's just really exciting that this has come about, and I'm so appreciative that both of you took the time to talk with us about this, to share with us even that this had been put into law to begin with, because we were not aware with our community, and we have so many women in our YMyHealth Health community who we knew needed to know about this as soon as possible. And to share with their friends. Obviously, child people of childbearing age, the majority of them are within the millennial generation. They're about, let's see now, 8 years, who, because we start now at 28, who are still in their earlier 20s, and they're Gen Z, but we welcome them in always too. So
As always, Melissa, thanks for letting us come on and talk about our niche little nerdy lawyer things we love to talk about. It's always a win win when we can help people too, and so that they know their rights. So thank you for giving us that opportunity.
you're so welcome. Julie and I are thrilled to be able to do that. And Noelle, thank you so much for not only coming on the podcast today, but also just taking the interest in this area of law.
Oh my gosh. Well, thank you for bringing me on and letting me share some of our nerdy facts.
You're
But
so
thank
wel-
you.
you're so welcome. Well, thank you both.